Mr. Howard, were you going to share any comments?
Yes, please. Thank you, Mr. Chairman. Members, Ed Howard, Senior Counsel for the Center for Public Interest Law at the University of San Diego School of Law. The center is a nonprofit, nonpartisan academic center of research, of teaching and learning and advocacy and regulatory policy based at the law school, and it's been doing that since 1980. The center's expertise has long been relied upon by this legislature, the executive branch, and the courts where the regulation of licensed professions is concerned. For example, in 2002, the Department of Consumer Affairs named the center's administrative director as the enforcement monitor for the medical board after a series of high-profile scandals. And CPIL staff have served similar roles for the Contractor State Licensing Board, the Athletic Commission, and the State Bar. During my 20 years of public interest practice, representing a variety of consumer, civil rights, and environmental organizations, I have appeared before the Athletic Commission, the Board of Chiropractic Examiners, the Medical Board, the Board of Accountancy, the PUC, the Department of Insurance, the State Lands Commission, the Coastal Commission, the Court Reporters Board, the Acupuncture Board, the Nursing Board, and several other bureaus. Likewise, when I was chief consultant here in the legislature for the Joint Committee on Boards, Commissions, and Consumer Protection, my job at that time was to review, along with my staff, on behalf of Senator Figueroa, all of the state's boards and commissions, not just the ones under the Department of Consumer Affairs. And the reason I went through all of that is because when you take the accumulated weight of that experience, I think it is regrettable to say that what we see here, Mr. Chairman and members, is not just, as Senator McGuire said, a culture of coziness. It is far worse than that. It is, in our opinion, an unprecedented example of lawlessness at one of the most important regulatory agencies in the state of California. And it is unprecedented to the degree to which a regulated entity sought and successfully sought to control the terms by which it is being regulated. It is likewise unprecedented insofar as we do not see in the email exchanges any awareness that what's going on is wrong. In fact, in many ways, the most shocking thing about the emails is that they exist. Because if there were actually any sense that what was occurring was untoward or wrong, you'd pick up the phone and say, hey, don't put this in an email, meet me for a cup of coffee. So when considering legislative responses to what, in our view, is an unprecedented culture of lawlessness, it means that the responses need to be proportionate to the law breaking. And on that note, we have three proposals. The first is, as the professors have all mentioned, ex parte communications in adjudicatory proceedings are already banned. But given the culture of lawlessness, we need teeth to that. And the teeth has to make it clear that the person who might be tempted to, for example, try to handpick their own judge for a multi-million-dollar rate-setting case will not succeed if it is discovered. And so the two remedies, the two incisors would be, if you violate that, mandatory recusal for the commissioner and staff that were the subject of the communication, and a ban forever from the individual on the outside ever being able to practice before the PUC again, the equivalent of being disbarred. That way, the consequences would be very dire for the regulated entity, and it would mean that their effort to engage in ex parte communications might in fact backfire on them, both personally in terms of their careers, but also in terms of the success or failure of the adjudication. The second, as the professors here, was an excellent testimony by my panel colleagues, by the way. The second is, while in the law there is some blending of whether or not rate setting is a legislative or an adjudicatory function, again, given the culture of lawlessness here, we endorse the recommendation wholeheartedly of my co-panelists, and that is that the moment that a rate setting becomes an adjudicatory proceeding, ex parte communications should be entirely banned. I saw Senator McGuire you're nodding when talking about the value of the adjudicatory proceeding, it is extraordinarily odd to allow any kind of ex parte communications while you're using the regulatory tool of an adjudicatory proceeding. An adjudicatory proceeding doesn't just satisfy constitutional due process requirements. It is a regulatory tool whereby we decide that the best way to test what is being said to come to the best possible decision, regardless of constitutional issues, just the best possible decision, is to throw the arguments and the evidence into the crucible of the adversarial process. It doesn't matter whether or not you've got a meeting with all hands on deck and it's ex parte during a rate setting. There's not going to be a formal cross-examination in the same way that there would be in court. Likewise, and at minimum, even if under current law, the all-hands meetings would be preserved, and again, we're with the professors, we don't think they should be. At bare minimum, the ability lawfully to meet on an individual basis with staff or commissioners in a rate-setting proceeding ought forever to be banned. Why? Respectfully just explained it. It is absolutely inimical to the whole concept of having claims and argument and evidence tested in an adversarial proceeding when it's not a proceeding and when it's not adversarial. The teeth, again, the same too. If you violate this ban, you are automatically recused, both staff and the member, and the practitioner is automatically, quote unquote, disbarred from ever practicing before the PUC again. Finally, and something not touched on by the professor's report, we think that the culture is so lawless here that ex parte communication bans ought to be extended to quasi-legislative proceedings when, meaning just straight up regulations, when the formal proceeding has begun. When the formal proceeding has begun, just like in court, we have the Bagley-Keene Act, and public comment is supposed to be channeled through comments that are public. The ability simultaneously with public comment going on to be able to have serial and secret conversations about the very thing that the public comment is talking about makes the public comment a charade at best and a mockery at worst. Now, that would be during the formal part of the proceeding. Our proposal does not seek to ban ex parte communications during the run-up before regulation is promulgated. In reality, as practitioners will tell you, that's where most of the work gets done anyway. Once regulations come out for public comment, they are very rarely changed very dramatically. But nevertheless, ex parte communications would be permitted under our proposal leading up to a formal regulatory proceeding. But once the formality begins and the transparency and accountability is supposed to be public, then given this record, regrettably, we think that there ought to be a ban during the public comment period on ex parte communications. That concludes my testimony. In sum, I think that it is extraordinarily regrettable that we are here. The idea that we have a multi-billion-dollar company that was successfully able, through ex parte communications, to select its judge. I mean, let's just say she has a history of being very hard on us. I can see if anything can be done. Take a deep breath. I am working on it. That concludes my testimony.
Thank you. Do you have questions from senators? Senator McGuire?
Thank you so much, Mr. Chair. I have some questions and just some comments as well. Again, Chair, thank you so much for bringing this issue forward and appreciate the panel for the work that has gone into today. And I want to make clear before I make some specific comments and then also ask some questions is that, the PUC does have a lot of good people on their team. And know that there are a lot of individuals at the Public Utilities Commission that have dedicated their professional life to good work. And it is obvious there needs to be significant reform. My frustration in these comments are from my own personal experience as a member of a local board of supervisors in the almost impossible process to participate in the public process of the PUC advocating for ratepayers, which is darn near impossible to do through the intervener status program that they have. And this is why I use the term, not trying to be flip, but trying to summarize why I believe there really is a culture of coziness at the PUC. Ms. Beals discussed the potential of an unfair advantage, and it absolutely exists. It is almost impossible for the public to participate, and we'll use a rate-setting case, and to be able to advocate their point. Represent the poorest county in the state of California, Lake County. And there is a small water district in a small community of Lucerne that has among the highest water rates in the state. Ridiculous. And to expect residents to travel all the way down to San Francisco to be able to become an intervener, which is so difficult, is nearly impossible. And we can look at utility districts across the state. And I know that Senator Hill, and again, Senator Hill, thank you for all your work, has been focused on another side of utilities. But I have to say, the reason why there is this culture of coziness is because if you don't have deep pockets or have the team to be able to advocate for what you need, you're almost out of luck. And it's embarrassing and it's no longer acceptable in this state. And we have become, unfortunately, the exception and not the rule across this nation. I have to say, as a legislature, I know we need to be focused on cutting through the bureaucratic red tape to ensure that residents have the ability to be able to comment on those issues that impact their quality of life. I will tell you, we have seen rate hearings put onto the backs of ratepayers that if this were at a local city council or at a board of supervisors would never be approved because they see those individuals in the Ray's Market or at Safeway and they actually are accountable. And what has happened and what we've created is an island where we have individuals that are not accountable to the public. And appreciate the reforms that you're bringing forward because I think it is long overdue. So those are my comments. I do have some questions. Can you just go into some detail about how other states involve the public in the decision-making process within their own utility commissions?
And I can provide examples even from the CPUC's process that could be enhanced. So under the CPUC's process, there is the potential, rather than conducting individual ex parte meetings, to have all-party meetings in which all parties can participate in the discussion. I am aware of a commissioner sending out questions and all the parties then preparing for those questions and there being an open forum, almost like a final argument. There is a potential for public participation hearings. There's not a lot of public participation hearings, but that could be a potential reform.
And here's my frustration, and I'm not trying to cut you off, but I'm just going to share. So there's a one and done hearing. So the administrative law judge, and I'm going to give you a very clear example. The PUC held a rate hearing in a community that isn't even within the water district of the residents that are impacted. So there is a private water company in the community of Larkfield. The administrative law judge and the PUC held the hearing in a town 5 miles north on the highway. And I'm sorry, and I know I'm sharing my frustration today, but it's absolutely ridiculous. And there has to be focus on involving that. So I don't have a whole lot of faith, being quite frank with you, on these one and done hearings because it's at times a farce.
Right, and what we've seen is that so much of the staff time right now is devoted to these individual ex parte meetings, that if less time was devoted to these individual ex parte meetings and more time could be devoted to public participation hearings, reaching out to the affected public, reaching out to communities like the one that you've mentioned, Senator McGuire, that could be a potential reform, a potential refocus, of the commission's resources, of the commission's efforts. There is a limited public comment period before business meetings. The majority of the business meetings, as you'll know, Senator McGuire, are in San Francisco.
Oh, yeah.
So that provides the same issue. There could be a potential for perhaps video comments or some other type of potential so that interested persons in other communities could also participate in those hearings. So those are just a couple of ideas expanding upon the current opportunities that are available under the CPUC. And I don't know if my panelists have other ideas to add.
I think that your point is a really, really good one. And it changes, and it points out, I think, in potentially an inadequacy in all three of our presentations. And that is that if you think we're focused on what shouldn't happen to unduly influence regulatory proceedings, but we're not looking at the other side of the equation, which is what you're forcing us to look at, Senator. And that is another way of minimizing that is to ensure that other voices, and maybe inoculating voices, are heard. And we have not put together a proposal that would do some of the things that you're talking about, but it is clear that that should be a part of the discussion, especially given, as my co-panelist pointed out, that nowadays you don't need to travel to San Francisco to have your voice heard. So an important part of the discussion, I think, senators, is not only restricting the ex parte communications, but also trying to figure out ways to reach out and have more people's voices heard throughout the state.
Just bringing it
Senator
back.
McGuire, I'm going to use this opportunity to set up an item because
Please.
it's very consistent with your question. You spoke very briefly about advice letters. Could you define what an advice letter is? I know in some instances, advice letters comprise the bulk of the decision-making process in certain areas. Is there a way to expand the use of advice letters consistent with this? And if you can explain what that is and how, and whether it's something that we should look at in our reforms.
I'll start out with perhaps just a little ancient history about advice letters. The concept of an advice letter came out of the logical process of making a rate case decision and then expecting the utility to be able to take certain steps to implement that decision. If you change rates, then the utility, for instance, needs to draft new tariffs and identify those rates and lay it out. The advice letter process really started out as just an effort to kind of close the loop. Have the utility file its compliance documents, and the advisory compliance staff would look at them and make sure everything was in order. If it wasn't, a flare would be sent up, and maybe another evidentiary process might have to result. But that's where we started. And over the course of time, I think the commission has tended to naturally want to expand the advice letter process because it seems to have less baggage attached to it in terms of the length of time it takes or the amount of formalized procedure. And so we see it being used now in ways that are fairly expansive. Is it advisable to want to expand the use of advice letter further? I think it would really probably depend on whether the commission and the legislature could agree on very explicit definitions of what an advice letter is and what the procedure is that's going to have to apply to it. Because I think right now it's largely just seen as the second less resistant vehicle for getting things done.
So,
Go ahead.
no, thank you so much, Mr. Chair. And just on this, and I'll finish up here very quickly, Mr. Chair, is that there are four items that I would love, through the chair, be willing to look at. I mean, there are some basic reforms, and I know it sounds a little ridiculous, but you have to host the hearing in the community of impact. Mm-hmm. And that's currently, at times, not done. Two, there needs to be a reform on intervener status. To be able to expect the normal neighbor to participate and become an intervener is near impossible. And there needs to be a focus on that intervener status and how that evolves. Would love to be able to work with you on that through the chair. exactly what you're talking about. And I think it was Mr. Weissman, and I'm paraphrasing here, says that sunshine solves a lot, right? And how public input, whether it's Skyping in, what have you, we need to be able to move towards new way to communicate. And I think the other piece is, and I'm going to just focus on rate hearings here. I'm also interested on what neighboring communities have in regards to where their rates are at. So a lot of times, if you're a public, you compare where your rates are at with your neighboring communities. Frankly, we need to look at other variables when it comes to increasing of rates. Social economic status of a community, obviously comparison of rates. I totally get if you have to build a new, whether it's a wastewater treatment plant or a new water treatment plant, there may be some additional variables that you're going to have to take a look at. But it's my belief that these aren't looked at nearly as much as where does that utility need to be able to go to be able to, one, hit their bottom line and return back to their investors. So I think there also needs to be some additional variables. And my last item is this. And the most immediate concern that I also see as a big picture right now when it comes to the state is Diablo, our last remaining nuclear plant, and serious concerns over the seismic safety. I'm not going to go down that road right now, but ensuring that any communication and decisions about Diablo is going to be open and transparent. And I think that's going to be another one, but I know that's for another day. But I think a most immediate concern related to this.
Senator McGuire, I think you've hit on a couple of important points related to how you can effectively increase public participation in the process. There's only so many ways it would seem that you can actually shoehorn more public comment into a proceeding in a state where you've got in excess of 30 million people. But you touched on one, which is to have more local hearings. This is something that is usually, at this point, frankly, constrained more by budget than by interest in having local hearings. But I can state from experience that sometimes you hold the local hearings and maybe the first day people show up. After that, perhaps not. And I think there needs to be some flexibility to be able to know when you need to be there to respond to local interest and when not. But I think one of the other things you hit on that's very important is that participation isn't just a matter of receiving. It's also a matter of sending out the information that's necessary for people to be informed and participate in the process. One way to do that is just to provide more focus on providing written information, website information. Another, I think, is to increase the Commission's focus on its relationship with local governments, because local governments are in position to communicate more effectively with their constituents. And over the course of time, there was a time when the Commission had a local government ombudsperson who would wake up every day and think about, well, what proceedings are there going on that are going to be of interest to local communities? What are things we need to let them know about? Where are places where we want the input from local governments? And I think that process ought to return. And then finally, I think there's some room for creativity in terms of how the public hearings, the public statement hearings, as it's called in New York, or the public participation hearings in California, how that process works. I was involved in a very controversial dam proposal in the Monterey Peninsula a number of years ago, and we had a series of community meetings with 100 to 150 people in attendance, and we heavily facilitated those meetings. And what we did was try to help the community prioritize what it saw as alternatives to the dam. And then those priorities wound up getting turned into additional legislation that was signed by the governor that created a process called the Plan B process. So there are ways, I think, to try to improve the quality of the communication that's going both ways.
Really appreciate it. Thank you so much again.
Senator Hill?
Thank you, Mr. Chair. I have two questions. Mr. Howard, you did nice tan, by the way. I have two questions. One related to the issue of violations and sanctions or punishment for those. And I guess what I want some clarification is you seem to be reflecting heavily on the lawlessness aspect of the history of the PUC commissioners and their behavior as well as the utilities. If you look at, the commissioner who is probably the most egregious, the most lawless, is no longer there. There's another commissioner who's, I think the jury's still out on whether his behavior will indicate further challenges and ex parte communications. So I guess what I don't want to do is overburden the new PUC, as I'd like to define it, and call it, with things that are reflective of what happened in the past which were more unethical, immoral, and illegal than behavior that I think we can hopefully characterize as healthier in the future. So would you change you're looking at this, and maybe this is for the other panelists as well, without having that as a history?
No, and I think for two. Oh well, I think no, depending on, because there was a double negative in there. So and thank you for the compliment. No, I think, and for two reasons. The first is, one of the things that I'm asked a lot is, having surveyed all these boards and commissions, how come some of them are always problem children and some of them aren't? And the answer really very frequently isn't just in the codes, because a lot of the codes are fairly similar. The answer really stems from Senator McGuire's point about the culture. One of the things that is common among the regulatory boards that repeatedly misfire is the degree to which the regulated entities or their associations lobby them, and lobby them with a sense of, if I may say, immodesty about enlightened self-interest. So if you want to look at those boards that are repeatedly in trouble in business and professions land, to put your other hat on, Mr. Chairman, or Mr. Senator, that I think is the common thread. So the examples that we have here in the 65,000 emails are only the examples that exist in the emails. They are quite literally, I think, the tip of a broader iceberg. And when you consider the overwhelming financial incentive for these extraordinarily wealthy regulated entities to do everything they possibly can, not illegally, but everything they possibly can to win because of how much money is at stake and how high profile they are, it is exactly those kinds of circumstances which commend to themselves proportionally the most powerful remedies for violations. Flip it to make it an easier example, if we wanted to write a statute that would dissuade huge financial fraud, right? We wouldn't put in the statute a penalty of $100. Why? Well, because it's not really an incentive given the countervailing interest in making a lot of money. So when you look at the stakes in the Public Utilities Commission's proceedings, many, many, many millions of dollars, it makes a certain amount of regrettable logic and sense that you would see this kind of overwhelming emphasis placed on lobbying and attempting to control the result. That's what the advocates get paid to do at the end of the day. So the first reason is I think that I don't think that the cultural issue, the underlying cultural economics, or the economics that led to the culture there, are going to endure. That is a permanent fixture of regulating these massive utilities is. The second reason I said no is because I don't honestly think that the remedies that we were proposing were really all that draconian.
No, I agree.
I think that if you violate an ex parte rule, then you ought not get the benefit of that violation by allowing that person to continue to be a decision maker in your case. Likewise, if you violate a rule that's that important to the integrity of the process, you ought not be able to practice before the commission anymore. So those are the two reasons why I think that it is proportional and why this is an endemic problem.
Very briefly, I'm here to tell you that the cultural issues that we're discussing are not new to the California Public Utilities Commission. They've been going on for as long as I've known the institution, and that's from sometime in the late 1970s. The problems the challenges are deep, and it's not really to be pinned on any one particular individual.
Thank you.
Thank you very much. I'd like to thank our panel for your wonderful presentation.
Thank you.
Can I ask a quick question?
Sure.
Thank you. Sorry, I know we're going a little long. So good morning. Thank you very much
We do
for-
have another panel, so.
Okay, it'll be quick. Until I was elected to the Senate recently, my dealings with the PUC was just about like everyone else, a ratepayer. I appreciate your comments, Mr. Howard, about the lawlessness, because as you learn about these issues, you wonder what is actually acceptable. So to hear it put so bluntly is appreciated. How do we change what you said, the general lack of checks and balances, and there's no accountability? If this has been going on since the 1970s, how do we change that? Because obviously it's not working the way it is.
Well, I think that the most important thing to do is to place the onus on the decision makers themselves to avoid inappropriate communications and to report on the ones that do occur.
Great, thank you very much.
Thank
We're
you.
going to bring our next panel. Our next panel are stakeholders in the process. We've asked people that regularly work with the PUC to share with us their experiences and their own recommendations as to how to improve the process. We will hear from Matthew Friedman. He is a staff attorney with the Utility Reform Network. Stephanie Chen is the Energy and Telecommunications Policy Director at the Green Lighting Institute. And Scott Wedge is the legislative advocate for the California Association of Electrical Workers. Welcome. We'll hear first from Mr. Friedman.